Under this topic, you are going to learn about whether the buyer can obtain a good title if the buyer bought the goods from a seller who does not have any title. The general rule is that no one can give what he does not have. This means if the seller does not have any title upon the goods, the buyer will not get any title, will not get any ownership upon the goods. This is because the seller cannot transfer a better title than he has himself. If he does not have any title, he cannot transfer any title to the buyer. Because by virtue of the general rule, no one can give what he does not have. This is by virtue of Section 27 of the Sale of Goods Act 1957. For example, let's say a seller sold a stolen car to the buyer. So, in this situation, the seller did not have any title upon the car. And when he sold the car to the buyer would also not get any title upon the car. And therefore, at any time, the true owner may claim the car from the buyer, even though the buyer had bought the car in good faith. This principle of law comes from the maxim nemo dat quod non habet. Here, this maxim, it means that no one can transfer a better title than he has himself. If the seller does not have a title, the buyer also will not get a better title than the seller, even if the buyer has paid for the value in good faith. Exceptions. Under certain situations, the buyer will get a good title, even though the buyer bought the goods from a seller who does not have any title upon the goods. First exception is under estoppel. This happens when the owner himself induced the buyer that the seller has the authority to sell, meaning the owner himself informed the buyer that the seller has the right to sell the goods to the buyer. So in that case, the owner will be estopped, will be prevented from denying the seller's authority to sell. Therefore, the buyer who bought the goods in good faith will get a good title upon the goods, and the owner can no longer claim the goods from the buyer. The buyer get a good title.
For example, A is the true owner of some books. He has the title upon the books. A then lent the books to B. B, as the borrower, only having possession upon the books. He does not have any title upon the books. Regardless of that, B then tried to sell the books to C. Now, C is the buyer and B is the seller. However, before the sale happened, C knew that the books will belongs to A. C knew that A has the title upon the books. C then asked A whether B has the right to sell the books to him. In response, A informed C that C may buy the books from B. In this situation, A has induced C to believe that B has the right to sell. Therefore, A is estopped from denying the authority of B to sell the books to C. A is estopped from denying the right of ownership of C. C has a good title upon the books.
The second exception is a sale which is made by a mercantile agent. Mercantile agent is a commercial agent, such as broker, auctioneer, dealer for goods, which is work by commission, where in the ordinary course of business, they have the authority to sell goods on behalf of the principal or on behalf of the true owner of the goods. Actually, the mercantile agent is not the owner of the goods. However, if the mercantile agent sells the goods to the buyer will get a good title over the goods. This is because the mercantile agent make the contract on behalf of the true owner. So therefore, the buyer will get a good title. And even though the mercantile agent sell the goods without authority or even without the knowledge of the principal, in that case, still the buyer who bought the goods from that mercantile agent get a good title. And therefore, the true owner will not have any right to claim the ownership of the goods from the buyer. The third exception is under the sale by one of joint owners. According to Section 28 of the SOGA, if the goods were jointly owned by more than one person, And if one of the joint owners who have the sole possession over the goods, that joint owner can sell the goods to another buyer. Therefore, the buyer under this situation can get a good title, even though the buyer bought the goods without the knowledge of the other joint owners.
This is an example for sale by one of joint owners. Anita, Batrisha and Cassie are students of UiTM Johor. They stayed together in the same room. They have agreed to share money, buying an iron for their common usage in the room. They are the joint owners of the iron, meaning each of them has the title upon the iron jointly. After some time, Anita and Batrisha graduated. With their permission, Cassie now is having sole possession of the iron. However, later, Cassie then sells the iron to Darwina. In this situation, Darwina is the buyer and Cassie, who is only one of the joint owners of the iron, is the seller. Darwina bought the iron from Cassie, who does not have the full title upon the iron. However, by virtue of Section 28, Darwina gets a good title upon the iron, even though she bought the iron from Cassie without the knowledge of Anita and Batrisha.
The fourth exception is the sale under a voidable contract by virtue of Section 29. In this situation, when the seller who in the first place obtained possession of the goods under a voidable contract, but the other party did not avoid the contract, the buyer who bought the goods from that seller get a good title.
This is an example for a sale under a voidable contract. Under a contract, Azrin agreed to sell her laptop to Rosie. However, the contract was made under coercion, where Rosie threatened Azrin to sell the laptop to her under market value. Therefore, the contract is voidable. It means Azrin has the right to avoid the contract and get back her laptop. Nevertheless, Azrin did not avoid the contract. Due to that, Rosie obtained possession upon the laptop under a voidable contract. Rosie then sold the laptop to Linda. Thus, Linda is the buyer and Rosie is the seller. As a matter of fact, Rosie does not have the right to sell because she does not have a complete title upon the laptop. This is due to her voidable title upon the laptop, by which, at any time, Azrin may take back the ownership of the laptop from her. However, by virtue of Section 29 of the Sale of Goods Act 1957, Linda has a good title upon the goods, if she bought the goods from Rosie in good faith.
The fifth exception is under Section 30 Clause 1 relating to the sale by a seller in possession after sale. This happens when the ownership of the goods has passed to the buyer, but the goods remain in the possession of the seller. Later on, the seller then sells the goods to another buyer. The second buyer here get a good title.
This is an illustration for a sale by a seller in possession after sale. Mr. Lau sold 2 antique china vases to Mr. Tan. Therefore, the title or ownership of the 2 vases passed to Mr. Tan. It was agreed between them before that Mr. Tan himself will come and collect the vases from Mr. Lau. Meantime, Mr. Lau continued in possession of the vases until Mr. Tan come to get the vases. Unfortunately, after 6 months waiting, Mr. Tan did not turn up to collect the vases. Mr. Lau then sold the vases to Catherine, and now Catherine becomes the second buyer of the vases.
Actually, Mr. Lau has no right
To sell the goods to Catherine because he is no longer having title over the goods after selling them to Mr. Tan earlier. However, with reference to Section 30 Clause 1 of the Sale of Goods Act 1957, Catherine obtains a good title, even though she bought the goods from a seller who is only having possession after sale.
Finally, the last exception is under Section 30 Clause 2 of the Sale of Goods Act. According to this provision, a sale by a buyer in possession after sale may pass a good title to the second buyer. This happened where the first buyer who obtained possession of the goods with the seller's consent. However, the title or the ownership of the goods remain with the seller. If the first buyer sells the goods to a second buyer, the first buyer can pass a good title to the second buyer, provided the second buyer bought the goods in good faith and for value.
For example, David entered into a contract selling his car to Alex. Alex will make the payment by installments. Meantime, David gave possession of the car to Alex. It was agreed between them that the title or ownership of the car remains with David until Alex made the full payment of the car. However, Alex then sold the car to Zaid without David's knowledge. The question is, does Zaid, the second buyer, get a good title upon the car, even though he bought it from Alex, who did not have any title upon the car? By virtue of Section 30 Clause 2 of the Sale of Goods Act 1957, Zaid gets a good title upon the car if he bought the car from Alex in good faith.
To sum up, the general rule relating to the transfer of title, no one can give what he does not have. This means, if the seller is not the owner, is not the person who have the title upon the goods, or does not have any right to sell the goods, in that case, the buyer also will not get any good title or ownership upon the goods by virtue of Section 27 of the Sale of Goods Act. And this principle of law comes from the maxim nemo dat quod non habet, which means no one can transfer a better title than he has himself. It means if the seller does not have a title, he cannot transfer a better title to the buyer. The buyer will not get any good title. The main example is if the seller sold a stolen goods to the buyer. So in this situation, the buyer will not get any title. However, there are exceptions to this nemo dat rule. There are 6 situations where the buyer will get a good title even though the buyer bought the goods from a seller who did not have any title or did not have any rights to sell the goods to the buyer. Under these exceptions, the buyer obtained a good title and the true owner cannot claim any rights of ownership upon the goods from the buyer.